appearing for the applicant.
Very well. Mr. Onoja.
Yes, my lord.
This is a Ganishi application.
Yes, my lord.
I've had cause to look at it, and it's obvious you are asking for the order of this court to attach the sum of 7.6 million naira.
Yes, my lord.
I've also gone through the judgment of this court, and I discovered that there was nowhere in the judgment where the court gave such an order.
You are asking for. Yes, my lord.
So I wonder how you arrived at this sum.
Exhibit K annexed to the application, and by Supreme Court decision and order 47 of the order of this court were entitled to interest. So that is the interest of on the judgment sum that make up the 7 million, and is back up with Supreme Court decisions.
How did you calculate the interest? How much interest?
10% interest. 10%.
On what? 10% interest on what sum? Of what sum?
On the judgment sum.
What is the judgment sum?
6,148,000.
Which paragraph of the judgment do you have that sum?
Sorry, my God. Judgment of court. Let me open my judgment. I'm sorry, my God. The judgment is, I'm sorry. Where is this? Sorry, my Lord. Sorry, my Lord. Even the terms of judgment aside, the terms of settlement 5. And then, where is it? That is the defendant, the judgment debtor is directed to compute the judgment sum, which was computed and filed before your lordship. And your lordship had even awarded 200,000 naira again. That is exhibit B.
Mr. Onoja.
Yes, my lord.
Which paragraph of the judgment gave that sum?
The judgment. After the judgment, there were a series of applications before this court.
Okay.
There is agreement before this court, which court also ruled on.
All right.
There is terms of settlement, which is terms of settlement that the court ruled upon.
That the court ruled upon when?
That is why I say exhibit B. Sorry, exhibit C.
Exhibit C.
Yes, exhibit D. Exhibit D is the ruling of court. That the amount was calculated. Exhibit D is the ruling of court. To look at exhibit D, the amount is computed by the parties and the court has already ruled upon.
Where is the ruling of the court?
Exhibit D annexed to the document. It is clear from exhibit B and D.
I'm looking at it. Court register. Do you have a copy of this? Mr. Onoja, let me just get the file wherein the court considered the terms. Has the judgment debtor been reinstated? Mr. Onoja. Mr. Onoja. Court registrar, is he offline?
He's online, my lord.
I can't hear him. And I can't even see him. Where is he? Is he in the courtroom?
Yes, my lord. He said he has been reinstated, my lord.
And let me see him and let him talk to the court. Let him unmute his phone.
My lord, he has been reinstated.
So the consent judgment, in the consent judgment wherein both parties agreed to the sum of 6,148,000 naira, is there any award for interest?
No, there's no interest in the consent judgment, and the law is that
where did you arrive at?
The law is that once interest is not pronounced upon, it becomes automatic.
Really?
Yes, that is why I have a Supreme Court decision and Court of Appeal decision.
Well, I have a discretion to, by the rules of this court.
The discretion is at the time of judgment. After judgment, the discretion.
So at this point, I cannot grant what I didn't grant earlier, and which was not.
Yes, that
because you are listening. Listen.
That is what Supreme Court says. If you did not make the discretion in the judgment.
You are now hinging this application on a consent judgment. In the consent judgment, parties didn't talk about interest. Consent judgment means parties have agreed. And that is what you are seeking to enforce. So how do you want me to enforce that behind the other party?
They will file after you grant this order. After this order is granted, they are entitled to file further affidavit. So you can argue. We'll argue it before you.
Before who?
Because if you grant this order, they will be served with
before who? Who is the you here?
Before the Lord, before me, Lord, sir. I'm sorry, before me, Lord.
Oh,
they will still file the process and will come before court and argue it. And all of us will supply authority. But I have supplied authority ahead of time.
Well, I'm not granting it.
We not talk. My Lord, the power lies with you, but we are relying on the Apex Court decision. It's just what the Apex Court says.
Mr. Onoja.
Yes, my Lord. Yes, my Lord.
You said the consent parties agreed to pay this be the consent judgment, which was delivered when? On 15th of June, 2022.
They have even breached the terms of the consent judgment. That is why we are coming by the issue. Yes, we have breached. If you look at our photo.
Here's a copy.
Yes, my Lord. So they have breached the term, and our processes as
Court registrar. Lokoja.
Yes, my Lord.
Do you have a copy of the ruling on the terms of settlement?
No, my Lord.
I need to see it before I can proceed with this. I need to see it because I can't find a copy in the file here.
My Lord, the copy has just been handed to me.
By who?
By the applicant.
No. I want to see the one in the case file. I can't find any in the case file here in Abuja. So I need to see it. I need to confirm. Because they brought Mr. Onoja. There was an initial motion ex parte for garnishee that was filed by the applicant on the 18th of November, 2021. Court registrar. And the motion was struck out. So I don't know how this came about. I need to see the case file. This case will be adjourned till tomorrow, this application. It's Onoja. I'm adjourning this application till tomorrow to be able to enable the court look at all the case files involved in this, including the terms, to confirm this before I proceed with this application. So this application is adjourned to tomorrow.
Stop this.
Call the next case.
Case number 2, NICN LKJ 17-2023, between Barrister Momo M. Baba and 1. Federal University, Lokoja. 2. The Governing Council, Federal University, Lokoja. 3. The Vice Chancellor, Federal University, Lokoja. 4. The Registrar, Federal University, Lokoja. 5. Professor S.M. Audu, Deputy Vice Chancellor, Federal University, Lokoja. 6. Mr. Reju M. Mela, Secretary, Federal University, Lokoja. 7. Barrister Ogala Omachoko, Head, Legal Services Unit, Federal University, Lokoja. 8. Professor Jacqueline A. Badaki, of Department Zoology, Federal University, Lokoja. Claimant is in court, my lord. The
defendants.
defendant.
The defendants, not first. All of them are represented by Oga Jacob Bella.
By who?
OJ Bala, legal officer, is representing all the defendants.
The registrar, the vice chancellor, Professor M.S. Audu cannot be represented. Mr. Ukeju Emela cannot be represented. Barrister Gala cannot be represented. Professor Jacqueline Badaki cannot be represented. So who is representing the first
My lord,
defendant?
Barrister OJ Bala, legal officer, is representing Federal University, Lokoja, and the Governing Council, which is the first and second defendant.
Barrister what?
OJ Bala.
Bala.
Yes, my lord. Bala.
What's his position?
Legal officer, my lord.
Federal University.
Appearances.
With utmost respect, my noble lord, A.Y. Mohammed, for the defendants, applicants.
No appearance for the claimant. Eh?
We propose to this honorable court BM.
BM what?
BM. Momo.
Oh, okay. You know what? Let me give directive to all counsel. If you want to address this court, because this is a virtual sitting, make sure the phone or the tablet or any system that you are using is placed in front of you, as I'm doing here, so that I can hear you clearly. If you are sharing with someone, when you want to address the court, you make sure you connect it and focus on it and address the court. And if you are not addressing the court, please unmute your audio. Mute your audio. You only unmute it if you want to address it, please, so that we'll help each other today. So, BM Momo. For the claimant.
Yes, my lord.
Very well.
Yes, my lord.
What application do you have, Mr. Mohammed?
Thank you, my lord. Is a motion on notice dated 10th day of August, 2023.
Mr. Momo, are you in receipt of this motion?
Yes, my lord.
Have you reacted?
Yes, my lord. I've responded.
When did you respond? Okay, you filed a counter on the 16th.
Yes, I filed a counter on the 16th. And I received this flower on point of law yesterday here.
Mr. Mohammed is challenging the mode of filing this process. Now you didn't specify the mode.
Yes, my lord.
Because you're asking for questions, framed questions for determination. And when you do such, it means you are coming by way of an originating summons. You framed how many questions? 7 questions. And then you are seeking for how many others? So is this an originating summons or a general form of complaint, if I may ask you?
My lord, we later discovered that an error, there was an error. So we will to amend our processes.
Discovered later that there was an error.
Yes, my lord.
So what do you want the court to do now? You want to withdraw this process and then come back properly?
My lord, we amend the one before the court will allow us.
You want to do what?
Court will allow us. We want to amend the process before the court.
Mr. Mohammed.
My lord.
My lord.
If you want to amend the process, what is the procedure?
My lord, is it the claimant?
Mr. Mohammed, unmute your phone, your audio.
I think the question is meant for you.
Well, I've earlier asked that, Mr. Momo, are you looking at the court or
Yes,
you're
my lord.
looking behind? Okay. I asked the question, and that is, yes, that is, if you intend to amend the process, what is the procedure by the rules of this court?
The procedure is to file a motion seeking the leave of the court to amend.
So have you done that in this case?
Is to file a motion.
Have you done that in this case?
My lord is in process. We are sorry. My lord is in process. We are sorry.
Since when? Legal practitioner.
We discovered this.
You want money, but you don't want to work. Lazy. Lazy. Mr. Mohammed.
My lord,
what do you have to say to this in the interest of justice?
My lord?
My
lord, sir.
I'm listening, please. Unmute your audio.
I did not hear the question.
Unmute your audio. Mr. Momo said he has realized the mistake counsel has done. So he intends to file an application for amendment. So I'm now asking you, what do you think about that?
My lord, by order 26.
My lord, by order 26.
By order 26.
Yes.
By order 26.
When read in conjunction with order 26 rule 1.
Yes.
When read in conjunction with order 5 rules 1 and 2. I do not think an amendment can cure this the defect. because the amendment is very fundamental. I mean, sorry, my lord, the defect is fundamental. I do not think an amendment can save the situation. It's a fundamental defect. And when that happens, the originating process itself has to go. And that is why we apply this application, my lord. Even if we apply the other 26.
May I ask this question?
Yes,
may I ask this question?
Yes, my lord.
When you browse through the processes filed by the claimant, what was your first impression?
Which of them?
What was your first deduction? The originating process.
Yes,
titled writ of summons.
Okay, that was.
When you read it, what was your first reaction?
In terms of the law or the facts, my lord?
Content and context.
My lord, to be very honest, I did not find the case as presented meritorious, to be honest. That was why we filed.
No, I'm not talking about the case.
The merits.
But the content.
We were confused. I was confused, my lord. That is why we have not been able to file any defense. I was confused. And I even explained to him when I came to court, because we are meeting for the first time. I told him, how do you want us to react? I was confused. We could have filed our defense if the defense was merely an irregularity. But I didn't know which way to go, my lord. It's confusing.
Okay, let me take your application.
As completed. My lord, the application is dated.
My lord. My lord, please. The claimant, please. The claimant, please. Based on, we want to humbly tell this honorable court that we are not ready today for the application, my lord.
Don't be smart.
You want to truncate your case. What's your reason?
We want to amend our processes first before we go for any other business.
Really? When I have before me an application challenging the competence, challenging the competence of the present or the extant process.
So, my lord, may I take the heed of the court to withdraw the process for now? Then we'll come.
Any objection?
My lord, no application, no objection to the application for withdrawal of this one.
The originating processes in this suit and all other accompanying processes are hereby struck out.
Stop it.
Call the next case.
The next.
NICN LKJ 03-2021 between Alison Abu and 1. Convicted Judicial Service Commission, 2. Chief Judge of the State. My Lord,
Parties are absent or they are in court.
yes, my Lord.
Appearances. Check your audio. Check your audio.
With profound respect to my Lord, I am Simon Musa. I humbly appear for the claimant.
Any other appearance?
With profound humility to this honorable court, I am ICB. I appear for the defendant.
My Lord, the matter is for continuation of defense.
Duke Esquire, are you ready to continue?
Yes, my Lord. But we would like to see the indulgence of the court to grant us 10 to 14 minutes stand down.
To do what?
His car
To do
broke
what?
down to come into court.
You want the court to do what?
Sorry, my Lord.
What do you want the court to do?
Seek the indulgence of the court to grant us 10 to 14 minutes stand down, my Lord.
10 to 14 minutes stand down.
Yes, my Lord.
Why? What's your
To
reason?
enable our witness, he called him earlier that his car broke down in the court.
Whose car broke down?
The witness.
And because his car broke down, he couldn't take another cab to come to the court. And this is 11, it's past 11. This is 12 minutes or 11 minutes after 11. Mr. Musa, what's your reaction to it?
Lord, we are sure that the witness is coming. We have no objection. Since it's just a 10 or 14 minutes standard.
Okay, stand down.
As a cop, please.
Call the next case.
Case number 4, NICN LKJ 2020 between Honorable Benga Amos Alabi and 22 others, and Kogi State Government and 2 others. My Lord, parties are absent.
This thing is not proper. Mhm. Who is in court?
All the parties are absent, my lord.
Appearances. Appearances.
Check your audio.
Any counsel for any of the parties?
Please, my lord.
Yes, my lord.
I am A. Onoja. My appearance.
I am A. Onoja, my lord. My
I can
appearance is for
see
the
you.
claimant.
I can see you.
Oh my God. What happened now?
Mr. Onoja, where are you?
We're having some little problem.
Any other
My appearance.
appearance? Any other appearance?
Me from the open court, my lord.
Mr. Onoja?
The matter is for defense,
Yes.
and they are not in court.
Were they in court at the last sitting
Yes, my lord.
in May?
Yes, yes, my lord. Ojukai was in court.
Ojukai was in court.
Yes, my lord.
So what do you want the court to do?
Lord, for fair hearing, if another date may be given to them.
What date?
22nd January, my lord.
Is it convenient? Court registrar. I mean,
Yes,
Mr. Onoja, is it convenient? Court registrar asking.
my lord, he said it's convenient.
Case adjourned to 22nd of January 2023 at the instance of the defendants for definite defense. Hearing notices to be served on the defendants proof to be filed.
Stop, please.
Call the next case.
Yes,
Yes.
number 5. LKJ 04-2022 between Simeon Achenyo Joshua, and 3 others, and Kogi State Government and 2 others. Parties are absent, my lord.
Appearances. I cannot hear you, Mr. Onoja.
All the claimants.
Any other appearance? New for the defense.
As officers.
Is it the same Mr. Ojuokai? Or is someone else?
Someone else, my lord.
Adegboyega Oluwafemi Adegboyega. Is the defense counsel online?
See him online, my lord.
You have seen him online?
No, my lord.
Is there any counsel representing the defendants in this case? Very well, kneel for the defendants. Mr. Onoja. Mr. Onoja. I cannot hear you.
Sorry, my lord.
Mm-hmm.
The matter is for definite defense, and we are saying that in the interest of justice, if they may be given another opportunity, my lord.
Court registrar, are you sure you served hearing notices? Because the matter was to come up on the 15th.
Yes, my lord. Sent emails. And we
And you
printed two.
informed? Okay.
We sent emails.
Okay. What date?
The same day. The same day.
What
23rd.
date?
23rd January.
What date?
23rd January.
23rd.
Thank you.
Case adjourned at the instance of the defendants to 23rd January 2024 for definite defense. Hearing notice to be served on the defense, proof to be filed.
Exactly.
Call the next case.
Yes, Mba. NIC LKG 07-2023 between Mr. David Okay and the Governing Council, Abubakar University, Ayimba, and 4 others. Parties are absent.
Appearances.
Need from the
Counsel.
office.
Any? Is there any counsel representing any of the parties? Omale Esquire, Major B. Esquire. No appearance, court registrar, no appearance. Give me a date.
24th January.
Case adjourned to 24/1/2024. Notices to be served of the parties proved to be filed.
Stop, please.
Call the next case.
Case number 7, NRCN LKJ 3M 2023 between Mahabami and Polaris Bank. Applicant is in court, my lord. Respondent absent.
Appearance.
I am here or not. My appearance is for the applicant.
Any other appearance?
My lord. JD, wait, please, because JD.
Use your sit down. Use your video as well. Excuse me.
Ubeche.
JD Ubeche.
That is JD initials. Ubeche is spelled UGBECHIE. I humbly announce my appearance for the defendant, judgment creditor, respondent.
Are you sure it's the judgment creditor?
I didn't get it.
Defendant, judgment creditor, respondent.
Yes, my lord.
Okay. Excuse me. Yes, Lokoja.
Yes, my lord. I have a pending application before the main application, my lord.
Yes.
The application is for extension of time to file further affidavit and my response to the preliminary objection, my lord.
When did you file this?
The application was filed on the 12th of May, 2023, my lord. 17th of May, sorry, 17th of May. 17th of May.
Mr. Ubechi.
Ubechi, my lord.
Ubechi.
Yes, my lord.
Are you in receipt of it?
Yes, my lord. We were served, but through on the face of the motion, I think they are responding to our trying to regularize what further affidavit and some points of law to our preliminary objection, which was filed on the 13th of April, 2023.
And they have since filed another counter affidavit.
They're asking for an extension of time.
Yes, my lord. Okay, they can, because the point I was trying to point was that the only response we have was in respect of an earlier filing we made, which we intend to withdraw because we have since replaced him by filing another counter affidavit that is dated 5th June 2023, to which we have not received anything from them.
Let me get you right.
Okay, ma'am. We
the applicant here. No,
yes,
just wait. Is seeking for an extension of time to file a further and reply on point of law. Yes. To your motion or reply on point of law in opposition to the let me see, and reply on point of law in opposition to the notice of preliminary objection that you filed.
Yes, my lord.
So what are you now saying?
Okay, what I'm saying, my lord, is that we filed an earlier counter affidavit to their motion. That was on the 13th of April.
Which motion?
The motion for
the original motion
for the judgment of the Honorable Court. And when we filed, we raised an objection that a particular officer of the bank that deposed to that affidavit, being a lawyer, did not affix his name. So we now, by way of response, got the appropriate, another officer of the bank with the appropriate capacity to depose to the same set of facts, which we filed on 5th of June. And our intention is to withdraw the said earlier affidavit filed on the 13th of April, and then place reliance on the one we filed on the 5th of June. So the application, the application they are trying to regularize is in respect to the earlier counter affidavit we filed. So I don't know.
The counter affidavit that you filed, is it titled to preliminary objection?
No, not in respect. The preliminary objection, there are not any issue of preliminary purposes. We didn't find any.
They have just filed a further affidavit and reply on point of law. Okay. In opposition to the notice of preliminary objection. That's the title if you look at the first prayer.
Okay. But if they are amended to be, we don't have any objection.
More in terms of the application.
As stop places. In the absence of any opposition to this application for an extension of time, filed on the 17th day of May 2023, we are with the kindness of court, move in terms of the motion paper. Thank you, my lord.
Order is on spirit.
As court places, most grateful, my lord. My lord, we have an application before your lordship. The application is filed on the 20th day of February 2023. If it is convenient for court, we are ready to proceed.
Go ahead.
My lord.
Thank you. Thank you, my lord.
I don't know if I can come in.
The application.
We have a notice of preliminary objection.
Pray your lordship for two reliefs,
which we feel should take
precedence. Mr. Lokoja, I hope you are hearing.
Yes, my lord, I'm hearing. I'm hearing.
Okay. So he said
we have a notice of preliminary objection. The 12th day of April 2023. Challenging the decision.
Filed when?
And filed on 13th of April 2023. Which we feel evidence by way of hearing order over the application, which the claimant judgment debtor applicant is seeking to move.
Please mute your phone. Mute your phone in the courtroom.
Okay.
Lokoja courtroom, mute your phone because there is this noise here. You filed a notice of plenary objection.
Yes, my lord.
Together with the counter.
Yes, my lord. We have a counter that is dated.
They were all filed together on the 13th of April.
The counter that we seek to withdraw, which is the one filed on the 13th of April 2023.
Counter is not
the same date as the preliminary objection.
That's what I'm saying. So I'm looking for your preliminary objection.
We are seeking to withdraw that earlier counter and in its place reliance on the one filed on the 5th of June 2023.
You tell me the rule that says the provision of evidence act.
I'm even looking for the preliminary objection. Did you title the preliminary objection as a preliminary objection?
Yes, my lord. The title notice of preliminary objection is dated 12th day of April and filed on the 13th of April 2023.
Only.
So you filed a notice of preliminary objection to the main motion on 13th of April 2023.
Yes, my lord, that's correct. Okay, with the name of the court, we would like to move the notice of preliminary objection.
Mr. Onoja, have you reacted to the notice of preliminary objection?
To the notice of preliminary objection.
When did you react to it?
That is part of what I applied for extension of time that was granted this morning. It was,
yes, when did you file the main? Okay.
On the 17th of May, 2023.
Very well. So move the application.
As of
I'm most obliged. My Lord, this is a notice of preliminary objection dated the 12th day of April 2023. Filed on the 13th of April 2023. It is brought under the inherent jurisdiction of this Honorable Court and pursuant to the provisions of Order 17, Rule 9 of the National Industrial Court of Nigeria, Civil Procedure Rule 2017. Lord, the ground upon which this notice of preliminary objection is predicated is as contained on the face of the motion paper and numbered A, B, and C. My Lord, in line with the rule, we have also filed a written address which we wish to adopt as our oral argument and submissions in support of this notice of preliminary objection. My Lord, by way of abbreviation, on the on the 7th of July 2023, 2022, my Lord, sorry. On the 7th of July 2022, this Honorable Court delivered a judgment in this matter, which by the very admission of the applicant was a well-considered judgment of the Honorable Court. This application is seeking to vary the said judgment of the court. And our contention is that the judgment of the court, the said judgment of the court being a judgment on the merits, of this Honorable Court of the jurisdiction to entertain this application as the court functions of truth. My Lord, in view of the aforesaid, we are therefore contending that this application is an abuse of court process and should be struck out.
Very well. Mr. Onoja.
Thank you, my Lord. In response to the notice of preliminary objection, the respondent has filed a reply on point of law in opposition. The reply on point of law is filed on the 17th day of May 2023.
Mhm.
Lord, with the kindness of God, we seek to
Yes.
adopt the said reply and point of law by urging your lordship to discountenance with this purported notice of preliminary objection,
Mhm.
while adding, as my colleague has added, we are done to urge on your lordship to take cognizance of the Supreme Court decision in GTB versus Innocent, which was just delivered this year.
Mhm.
To so add that court of law, such as this honorable court, has power to set aside its judgment where the necessary conditions as stated by law are placed before court, as in the instant case, just as Supreme Court has.
What are the necessary conditions?
The necessary where fraud is indicated, where evidence is deliberately withheld by the respondent as they did, as we have indicated to your lordship in our affidavits, based on the judgment itself and exhibit tendered in court without addition. The facts are contained in the judgment, the facts are contained in the pleadings, the facts are contained in every document placed before court, but they deliberately withhold to benefit fraudulently from
And you
it.
didn't see that. You didn't see that to raise it during the pendency of trial that they withheld a particular information because it's your case.
My Lord, I am not the counsel that conducted the case. I was briefed after the judgment was delivered, and when I look at it, juxtapose it with the law of this court and the rules of this court, that's why we came under the appropriate law and rules of this court to set aside the judgment.
Very well.
Yes. Thank you, my Lord.
I'll go through.
As copies. So back to the main application, my Lord.
No, my Lord, we are almost practically resting our, even on the surface of the emotion, saying that this cannot stand.
My emotion now.
An attempt to relitigate a suit in respect of the court statement through the back door.
Allow me move my emotion before you can rest on it now.
I'm only responding to the court.
No, I have to look at it. I asked the question whether you reacted to the reply, to your reply to the notice of plenary objection. So move your application.
Thank you, my Lord. This application is 20th day of February 2023.
Which of the application? The substantive application?
Yes, I'll consider it together with the
order and contains 6 grounds upon which 10 grounds upon which this application is brought to court.
Sorry, my God, I don't know.
Please,
whether I'm sorry, just a minute. I won't take more than a minute. I was wondering whether it will not be more tidy for me to withdraw the earlier application before you move.
2 counters.
Withdraw
the application the earlier counter affidavit,
Okay, yeah, if you want to withdraw it, go ahead, because we want to listen to
withdraw our earlier counter affidavit.
Please allow me move my application.
Mr. Onoja, listen. Council wants to withdraw the first counter to your main application.
Lord, I have responded to that counter, and if he's withdrawing that counter, I should draw our attention to the law that permits him to withdraw counter. Counter is not a motion. Rather, what he has done is an abuse of court processes. It's only motion that you withdraw.
You have reacted to the counter.
I've reacted to the counter that I say want to withdraw.
Have you filed any counter to the one you are withdrawing? Any other counter?
I filed another counter affidavit. It is
served on Mr. Noja.
duly served.
When did you serve?
I think the return is.
When did you file the new one?
We filed on 5th of June 2023. It is basically the same thing, and all force with the one we replace it with. It's just a question of the competence of the person who is deposing to the affidavit. All the facts are the same. So it's just
because of what?
Of the objection that the bank shall depose to it, being a legal practice, not attach his to it, and to that extent that it's not proper for the court, which was a question of irregularity. So what we did to now get another officer of the bank, in fact, the person who deposed to the affidavit used throughout the trial to depose to the new counter, and leaving the two there hanging amount to duplication. So it is within our right to say, okay, we are withdrawing the earlier one and placing reliance on the second one, filed on the 5th of June.
So you filed the new one in June?
My lord, yes.
June 2023.
Yes,
and you said it has been served on Mr. Noja. Mr. Noja, are you receipt of the new counter filed in June?
Receipt of the new counter, and what we are saying is duplication.
Just a minute. Listen. Are you in receipt of it? Did you react to it or not?
I can't react to it because this is an abuse of court process. We have joined issue with what you want to withdraw. You don't correct.
What's the issue? What's the issue that you joined with the first one?
Is that a lawyer deposed to the affidavit and he does not have a seal annexed to it. So he wants to withdraw that. I won't join issue with that. And if you want to withdraw that, you will withdraw the entire motion. You don't withdraw part of a motion.
That's not a motion. You filed a motion.
You don't even withdraw counter. It's not a motion. It's not a complete process.
He can withdraw a counter if he wants to. He filed the process. Every party has a right to withdraw any process filed in court.
Lord, I'm still learning. That is why I say if you draw my attention to a particular law that says you can do that, I have no problem. But he is saying that because we join issue with what he filed, he wants to withdraw. If he files something, we should not join issue with it. We have joined issue with what he filed by law. And he said because we join issue, he is withdrawing it. The court has to rule on the issue that we join, one way or the other.
What was the issue you raised?
The issue
you filed a reply to the counter.
My lord?
Did you file a reply to the counter they are seeking?
I filed a further affidavit to his counter affidavit.
And he there raised the issue of the fact that the lawyer that deposed to it didn't fix
yes, he's supposed to affix seal, NDA seal, which he does not affix. He doesn't have.
No, just a minute. Let me ask a question.
Okay.
The counter filed, is there a seal of the lawyer that filed the process, not the deponent?
The deponent is a lawyer.
No, I'm asking you a question. Did the lawyer that filed the counter affix his seal?
He did not affix his seal.
The lawyer, not the deponent.
The lawyer is the deponent, my lord.
I am asking you.
Okay.
Are you the one that filed the counter?
It was my colleague in the office who was coming to this one.
Who was the deponent? Who filed the process? The person that filed it, not the deponent. The person that filed it. Did the person affix his?
Yes.
Did he affix his stamp or seal?
You know, it's a counter affidavit. All you don't need for the court to evidence that you have filed it, that you have gone through all the processes required by law to be deemed to have been properly for the court.
Well, I'm taking the main motion. So, Mr. Noja, continue.
Thank you, my lord.
Whether or not you're allowing this one to withdraw, go ahead with your motion.
Lord, the motion is supported by a 48-paragraph affidavit deposed to by the applicant himself, Mahabame. Annexed to the affidavit are 5 exhibits marked as exhibit MD1 to MD5. Now, with the kindness of God, rely on all the paragraphs of the affidavit and all the exhibits annexed thereto by urging your lordship to grant this application. In compliance with the rules of this, honorable court,
Go ahead.
the applicant filed alongside with the motion a written address of counsel dated 20th day of February and filed the same day. With the kindness of God, we adopt same as our argument in this application by urging your lordship to grant this application.
Very well.
The applicant was served with a counter affidavit dated the 13th day of April 2023
Filed
13th day of April 2023 and in response to the counter affidavit, the applicant filed a further affidavit filed on the 17th day of May 2023 and the reply point of law. The further affidavit is of 20 paragraphs, my lord.
Very well.
We rely on all the paragraphs of the further affidavit. And equally seek your kindness to adopt the reply on point of law annexed to the further affidavit by further urging your lordship to grant this application. As we cap it up with the recent decision of the Supreme Court in Guaranteed Trust Bank versus Innocent delivered this year. My lord, sir.
Yes.
Further to this counter affidavit, which you have responded to, the respondent further files a second counter affidavit, which now amounts to duplication of processes before court and abuse of court process, which in essence, the respondent urges this court to discontinence with the counter affidavit they so filed in this case by act of abuse of court process. May it please court.
This motion.
5, 23 paragraph affidavit. Equals to one Mr. Paul Anima Sham of Human Capital Development Department of Judgment Credit.
The one that you filed earlier, you deposed to it. One call Anima Sham of
5 of June 2023. And earlier on, we had also filed a counter affidavit deposed on the 13th of April 2023, which we hereby seek give of court.
You filed it when?
13th of April 2023. Hereby seek give of court. And place full reliance for the purpose of the application reliance on the counter affidavit filed. The counter affidavit has attached to it 4 exhibits. Marked exhibit A to use of court. They have also filed a written address in opposition. Which we adopt as our oral argument and submission in support of counter affidavit. My Lord, we propose to place reliance on all the paragraphs of the affidavit, the attached exhibits, and the written address therein.
Yes.
In urging the court to dismiss this application with substantial cost once a court of competent jurisdiction has given judgment on the merits such as this honorable body plans the judgment of July 2023.
Very well.
I didn't leave before I thought out.
Mr. Onoja.
Yes, my Lord.
Mute your phone.
I'll stop listening.
Go ahead.
Yes, my Lord. By way of, I just want to add that this application is just a backdoor resource.
You didn't state that. Did you state that in your?
I thought it was to dismiss the application of
Very well. Mr. Onoja, did you file any reaction to the counter?
The second counter affidavit is an abuse of court process and it does not requires my reaction.
Okay.
Yes, my lord. And the argument that once the preliminary objection is still true, there will be no need for the motion. I think I submit that, my lord, that is a lame argument. And admitting to the fact that he is not objecting to the main application, as we urge your lordship to so hold. Very please court. Thank you.
It's writing.
Please mute yourself. Mute yourself.
I've
Mr.
copied.
Onoja, everyone should mute themselves. I'm writing the ruling. HR Yaya, unmute your system, please. I mean, sorry, mute your audio. Mute your audio. RH Yaya, mute your audio, please. Everyone online should mute their audio. RH Yaya. Here is the ruling of the court. Before this court is a notice of preliminary objection filed by the respondent to the motion filed by the applicant. The law is that when the notice of preliminary is filed challenging the competence of the suit, it presupposes that the powers of the court to adjudicate on the suit is challenged. The law is of common that when a preliminary objection is raised, as in this instance, the court is to consider and determine same first before proceeding with the main suit or main application, as it is in this present. If need be, it is first before proceeding with the main suit, if need be. It is in the light of this that the court will first and foremost consider the notice of preliminary objection filed by the respondent and determine same before proceeding with the main application. The grounds for the notice of preliminary objection are that this court, having delivered the judgment in this case, has been fontus of issue, that there is no reasonable cause of action capable of conferring any jurisdiction on this court, and finally, that the entire claim against the respondent is designed to harass it and dissuade it from enjoying the fruit of its judgment. In response to the notice of preliminary objection, the applicant filed a reply on point of law and framed the sole issue. And in his argument, counsel submitted that the written submission of the respondent in support of the preliminary objection is an abuse of the process of court, being a replica of its counter affidavit file. I suppose the main motion, I filed, let me take this again. Being a replica of its counter affidavit file, I suppose, to the main motion before this court. I find this very strange in that what learned applicant's counsel is reacting to is a notice of preliminary objection filed by the respondent against his pending application, and not the counter affidavit filed by it to the main motion. It is thus a mere frivolity for learned counsel to veer off the main issue to be addressed and thus plunging into another realm. It is in the light of this that I find that there is no abuse of court process in the notice of preliminary objection, nor the written address in support of same filed by the respondent. Therefore, the notice of preliminary objection as well as its accompanying address are competent before this court. The main grounds of all the gist of the preliminary objection is that the main motion filed by the applicant is incompetent in that this court is fontos officium, having delivered a judgment in this case. The law is ensconced that when a court delivers a judgment in a matter, it becomes fontos officium. I agree with the submission of respondent counsel in this regard. It is also correct to state that when a court delivers a judgment in a matter, the only option left for any aggrieved party is to go on appeal. Equally true is the fact that the judgment of the court of competent jurisdiction or competent court of record subsists until it is overturned by an appellate court. It is in the light of the above settled position of the law that I find in favor of the respondent that this court, being fontos officium, cannot sit on appeal against its decision by taking any step as indicated or desired by the applicant, be the motion filed by the applicant on 20th of February 2023. It is in consequence that I uphold the preliminary objection. It is pertinent for the court to consider the main motion filed by the applicant in view of the fact that The consideration of the preliminary objection cannot be isolated from the main application before the court. Now, the applicant herein is by this motion, urging this court to vary its judgment delivered on the 7th of February and July 2022. The grounds are stated on the face of the motion paper. I peruse the affidavit in support of the motion, and it is apparent, read paragraphs 10, 11, 12, 13, 14, 15, 25, 26, 27, 28 to 31 of same, that the applicant's grounds is that he was not paid a salary in lieu of notice, and basically that the judgment was not meritorious. In response, the respondent filed a counter affidavit first on the 13th of April 2023. The applicant responded to same, and the respondent, in view of what the applicant called an incompetent counter affidavit because the deponent, being a lawyer, did not affix his seal on same, filed another counter affidavit on the 5th of June 2023, which the applicant refers to as an abuse of a process of court. It is true that in law, when a party files two processes with same fact and issues and same party, the subsequent process constitutes an abuse of a process of court. It is in that regard that I strike out the counter affidavit filed by the respondent on the 5th of June 2023 for being an abuse of a process of court. Therefore, what is before this court is a counter affidavit filed on the 13th of April 2023. I find it strange for counsel to raise such an objection to a deponent in a counter affidavit just because the deponent is a lawyer and he failed to affix his seal on the counter affidavit he deposed to. This, in my candid view, is a mere irregularity, and to agree with the applicant counsel will amount to technical justice, which has been long killed, destroyed, buried, and rotten in the grave of our corpus juris in this clime. I find the counter affidavit filed by the respondent on the 13th of April 2020 competent. Furthermore, it is important for me to state unequivocally that this court, as a superior court of record, having delivered a judgment on its merit, is stopped from relitigating a matter. Relitigating the same matter all over again. To do so will amount to sitting on appeal against its own decision, and that the law frowns at. The only exception to this rule is where there is an error which does not go to the root of the judgment. See Order 47, Rule 22 of the rules of this court, which permits the court to either rescind, vary its order, or judgment where such is granted erroneously in the absence of any party affected by it, in which there is an ambiguity or patent error or omission, or granted as a result of mistake common to parties. Going by the above exceptions to the general rule that the court cannot sit on appeal against the decision, the averments in the affidavit in support of this application clearly states that the applicant was not paid a salary in lieu of notice, which by the judgment of this court goes to the root of the court's decision. This court, by its decision, cannot vary same regarding the applicant's request. To do so will require a calling of evidence and retrial of the main suit all over again, which has already been determined by the same court. See the Apex Court decision, the recent decision of the Apex Court in the case of Refuge Home Savings and Loans Limited versus Alhaji Umaru Gakuwa and others. It's a 2023 decision of the Apex Court. It is in the light of all stated that I find no merit in the motion filed by the applicant on the 20th of February 2023. It is thus dismissed. I award no cost to any of the parties.
Thank you, Lordship, for the well-considered ruling.
Court Registrar, call the next case. The ones that were stood down. Okay, call the matter that was stood down.
LCJ 03-2021 between Alison Abuku Idoko and 1. Kogi State Judicial Service Commission. 2. Chief Judge of
the courtroom.
Parties are absent, my lord.
Appearances.
With profound respect to Simon Musa, and the claimant.
Any other appearance?
With profound humility to this honorable court, I'm ICD, here for the defendant.
Very well. Are you ready?
Yes, my lord. Lord, we have a pending motion before this court.
What you told the court was that your witness on his way that the vehicle had issues. So which,
yes, my lord,
application again?
Sorry, my lord.
Which application do you have?
Okay, is there for extension of time?
To do what?
Within which the defendant's applicant may file the amended joint statement of defense and other accompanying documents.
Mr. Musa, are you in receipt of that application?
Yes, my lord, we are not in application.
Okay, move in terms.
The motion is dated 20th October and filed on the 24th of October 2023. With the leave of this honorable court, we move motion in terms of motion paper.
Order is as prayed.
As the court praises, we are grateful, my lord. My lord, the matter is slated for continuation of hearing, and we have our witness in court.
Invite your witness. Court registrar, invite your witness and let the witness be sworn in. Let the oath be administered on the witness. The matter is for defense. Sit down.
Okay.
Are you calling only one witness? Duke Esquire.
Yes, my lord.
Very well. So go ahead. In the position. Go ahead, court registrar, and administer the oath.
I, Ibrahim Adenoy, Swear in the name of Almighty Allah.
Swear in the name of Almighty Allah.
That the evidence I shall give in this case.
That the evidence that I shall give in this case.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me Allah.
So help me Allah.
What's your name again?
Ibrahim Adenoy.
Court registrar. I mean, Duke Esquire.
Yes, my lord.
When did you file the witness on oath of this witness?
On the 24th of October.
24th of October.
Yes, my lord.
Very well. Go straight to his sworn deposition.
Witness, can you please tell the court your name?
I don't need that.
Remember, on the 24th of October, 2023, you did make a statement before the registry of this court.
Yes, I made this deposition before the registry of this court on the said date.
Very well. What do you want to do with the statement?
Do you wish to adopt this statement as your evidence in this case?
Do you have any document you want to tender through him?
Paragraph 5 of your statement, you made At paragraph 5 of your statement on oath, you indicated series of promotion letters of the claimants from the Judicial Service Commission. If you see these documents, can you identify them?
Yes,
How many of them? How many of them?
2, my lord.
Very well. Show him.
Are these the documents you're talking about?
Yes.
What are the dates? What are the dates on both?
The date is November 2015 and 18th April 2013. 2020. 2011. The first is 18th.
I can't see you. Sit down and place the phone before you. Court clerk, help him.
Yes,
the first one is on the 3rd, 2015.
I have 2 of court promotion letters.
And the second
here.
is?
One is 3rd November 2015. And the other one is 15th April 2011.
I wanted for us to write first, but looking at it. Go ahead. So what do you want to do with these documents? Duke Esquire, what do you want to do with the documents?
My Lord, we seek to tender these documents in evidence. Certify through copy of the document. In evidence, my Lord.
Any objection?
My Lord, we have no objection.
Both documents are admitted and marked as Exhibit Ibrahim.
As the court pleases.
As the court pleases. My Lord, that will be all for the witness.
For examination.
As the court pleases. Please, can you tell the court when access of Kogi State Judicial?
I joined.
Sit down and talk to the court. Sit down.
Okay.
And
I
place
joined the
the
service of Kogi State Judicial on the 1st November 1994. 1st November 1994.
Go ahead.
And tell us the grade level upon which you were employed.
I was employed on grade level 2.
Me, I want to be bother myself.
Can you also tell the court what your monthly salary then was?
My first salary was 898 naira.
Go ahead, Mr. Musa, and stop just paraphrasing. Why don't you go to the main issue? The particular witness supposed to speak facts. Go ahead and ask him.
Yes, sir. Lord, I've asked present grade of the judiciary.
And I said, I'm a director on grade level.
Go ahead.
Can you also tell the court present month what it is?
Your present what?
Present monthly salary.
330.
Go ahead.
As a court, please. Yes.
300 down. 300 down.
Exhibit D Ibrahim exhibits. There are documents from the claimant's file, the judiciary.
Yes.
Which Benin Council, which document?
Exhibit D Ibrahim.
Exhibit D Ibrahim.
Yes.
No, the two exhibits admitted Ibrahim.
Okay, not Idigbe. Idigbe Ibrahim.
Referring to those documents or another one?
Yes. That they are obtained from claimant's side with the defender.
Yes.
Mm-hmm. Go ahead. Go ahead.
Not there. You you know that Alhaji Idris was governor of this state, 2003 to 2011, if you can remember.
Mr. Musa,
Yes, my lord.
please talk to your phone. Talk to your phone.
As a couple, I want him to confirm that Ibrahim Idris, governor of this state, between 2020, 2003 and 2011.
Yes.
I can't hear you.
You're right.
I didn't hear that
The
question.
is Alhaji Ibrahim Idris was a governor of between 2003 and 2011.
Okay. Yes. So it's not the current governor.
Yes, not the current. Between 2003 and 2011. You know,
Yes.
under his members of the Judicial enjoy enhanced salary pay.
Please, if you are not addressing the court, unmute your system, except the witness and counsel, so that I can hear him very well.
As a court, please. Why the right administration, the staff of judiciary enjoy enhanced salary pay?
Yes, it's true.
What's the name of the executive governor between 2015 and 2011 that you mentioned?
No, it's 2003 to 2011.
And what's the name?
Ibrahim Idris. Ibrahim
Idris.
Yes, my lord. And he confirmed that under his administration, staff of Kogi State Judiciary enjoyed enhanced salary scale.
Okay. Mm-hmm. Go ahead.
Yes. I challenge you that your statement in paragraph 7 that promotion of your staff, that your association had agreement with the defendants that your staff be promoted without cash backing. It's not true. I challenge you.
It's true.
Go ahead.
As a couple, do you have that agreement to show? You have the agreement entered between you and the defendant. Do you have the agreement here?
There was no written agreement. Yes.
Go ahead. Any further question?
Lord, we are coming very soon. Sorry, my Lord. Yes. Hello, that will be offered.
Any re-examination? Is that the defense case? Unmute your phone. Unmute your system. DW1, you are discharged.
My Lord, to put the record straight, is the DW2. We had a witness taken earlier.
They have already. When was that?
We had DW1.
When was DW1?
Let me just.
Okay, there was DW1 who testified in February.
Yes,
so this is
DW.
So this is DW2. So
Yes,
DW2, you are discharged.
As a complice.
What did you say? You said you have another witness.
Yes, my Lord, one last witness to close our case. Unfortunately, we couldn't secure his presence in court today due to ill health.
Mr. Musa, what do you have to say to that?
My Lord, actually, I see this as a ploy to further delay. Lord, this matter was a conclusion of evidence even before they brought this application for amendment, which was granted. And today again, just brought a witness seeking an adjournment. Because it's just an oral submission to say a witness is sick, and that Lord, is not enough.
My Lord.
My Lord, under the leadership, bringing us to court on piecemeal evidence is actually not convenient. Lord, my Lord could see that we took a witness in February, supposed to bring another witness in November, and they're still seeking for more indulgence. Lord, in the circumstance, we compelled to ask for cost of 50,000 naira.
Sorry, my Lord. My Lord, we didn't know that the case was actually slated for today because we called the registrar, the clerk prior, I think last week. So she informed us that the cases that were slated for last week were going to be moved to this week, whereas the ones for this week will be moved to next week. So we realized this morning that it was actually a misinformation on our own part.
What's the name of the witness that you said is not before the court? That is, you said is ill. What's the name of that witness?
Mr. Joseph Sunday Jisola.
And when did he depose to his
On the
witness
24th.
Well, the witness statement I have here is an incompetent one. Mr. Musa.
Yes, my lord.
Do you have the witness statement on note of the said Joseph Sunday? Do you have his witness statement?
Okay, court, please. Yes, my lord.
Was it signed? Was it dated? And is there a commissioner for all signed, seal and stamp?
My lord, it's not signed and not stamped. It's only signed by the deponent. Not
very well. So, Ms. Duke Esquire.
Yes, my lord. Sorry, my lord, it's not fault of our own. It's that of the registrar, the court registrar.
And you didn't see it? You didn't call the attention of the court registrar? Eh?
No, my lord. No.
Before the court now, there's no competent witness statement.
My lord, every other part was signed, but it's just this part. The witness deposed before the registrar. He was there in person too, my lord. My lord, the fault of the court cannot be meted on innocent party.
Well, I cannot say it is the fault of the court, because if you file the process in court, you said a witness came and the witness orally deposed to this before the commissioner for oath, and there is no date. He ought to have put on the date there before the commissioner of oath, who will now sign and seal and put the seal of the court. There's nothing like that, and you are telling me that it's the fault of the court, and you accepted it?
No, my lord, the day the process was filed, the commissioner for oath was not around.
So this is another story now. And they file it, you file it the same day DW2 deposed to his own. The commissioner for oath was around, he signed that one, but he didn't sign the second one. And you didn't raise any grounds since the 25th of October up to today.
My lord, we seek the guidance of the court to perfect it.
Yes, ma'am. But you said Ibrahim. Maybe because of the name of the business. Yes.
125. It is correct that the defendants have overly delayed this case. Their first witness was called in February 2023, and since then, all adjournments were granted at the instance of the defendant. Until in June 2023, when the court was to foreclose them, they filed a motion seeking for an amendment on the 24th of October 2023. The court, in its magnanimity, granted leave to the defendants to amend their defense, and the case was adjourned for the defense to continue their defense, failing which the defendants had to be foreclosed. Today, when the case was called at about 11 a.m., the defense counsel, Irene C. Duke, sought for a stand down of this case in view, and the excuse was that the defense witness car broke down and that is on his way. The court, irrespective of the fact that witnesses ought to have been in court, seated before its sitting commenced at 9 a.m. this morning, granted the request of counsel for a stand down. This case was recalled at about 1:25 p.m. this afternoon. And counsel has actually called his witness who has testified and cross-examined. Now counsel is again seeking for an adjournment to call another witness who on record has no competent witness deposition. And the reason being that he is indisposed. This court is a court of justice, and courts of justice must ensure that justice is done to all parties. To grant the defendants an adjournment again to call an unknown witness before this court will be to overreach the other party and occasion injustice. The order of this court of the 18th of October 2023 stands, and that is that the defendants are to conclude their defense today, failing which they are to be foreclosed. It is in view of this order that this court closes the defendant's defense. Parties are to file their respective final written addresses. What date? Court register for the 9 days. The defense will file first, serve an advance copy on the claimant, who will equally respond. So what date?
10th January.
10th January, is it convenient for adoption? What date?
23rd January.
23rd January.
Yes, my lord.
Is it convenient to both parties?
Yes, my lord. Convenient, my lord.
Okay, so adjourned to 23rd of January 2024 for adoption of final addresses.
Please, God, please.
Any other matter?
All for today, my lord.
Very well. The court will rise.